When clients come to see me on a consultation regarding custody matters, first of all, I recognize that whenever we're talking about divorce, without exception, the most important issue to every single spouse in the case is the children. That's what they want to talk about first. And so I respect that as a father, and that it's a very difficult situation. Clients should be aware that there's a very significant law change in West Virginia in June of 2022. The West Virginia legislature completely changed the factors to be considered in awarding a custody allocation. We call it custodial allocation, is the schedule that essentially each parent enjoys with their children. And prior to the law change, the court was to consider the percentage of caretaking functions each parent did for the children on a daily basis. So they wanted to know things like who got the children up in the morning, got them breakfast, off to school, who was there when they got home, who fed them dinner, who did homework, who did their laundry, who bathed them before they went to bed. And these were all made up of caretaking functions. That analysis completely changed in June of 2022, and the legislature passed the Best Interests of Children Act, and now it simply provides that there is always, in every case, a rebuttable presumption, but it starts with a very strong presumption that custodial time should be shared equally between two parents, irrespective of caretaking functions. So, for example, if you have a parent, let's say the father, gets up every day at 6 a.m. and goes to work and isn't home until 8 or 9 o'clock at night. Under that case, under the old law, the mother would have provided most all of the caretaking functions. And the schedule that would have come out of that situation is the mother would have continued to have the majority of time with the children. The new law change, which creates the presumption of equal time, says that the time that the father spent out of the house earning a living and providing for the family is a parenting function and is as equally important as the caretaking function. So that creates now the presumption that even the father that had been out of the house 12 hours a day is nonetheless going to be presumed to be entitled to an equal custodial schedule with his children. There are some exceptions under the rule, and there are other factors the court can consider: substance abuse, domestic violence, child abuse, gross acts of misconduct, but they must be significant to rebut the presumption. And so it can be rebutted. It's not an absolute, but it is a very strong presumption, and the law changes. All of the family law practitioners we're all getting used to it. The judges are getting used to it, and every situation is unique. And understanding that children are the most important thing, and the custody schedule is usually the most important thing to spouses that are going through a divorce. So if it's important to you, meet with a qualified domestic relations family law attorney that is up to date on the new law and is not operating under what used to be the standard, because you have to know what you need to do to either get the presumption or rebut the presumption, depending on which side you're on. And we advocate strongly for our clients. We advocate for the parent that comes in and retains us to do their divorce. Our motto is, we take sides. It's our job, and we take that seriously. And if there's any fact or factor that I can use to meet your objectives with your children, we're going to get that evidence in front of a judge so we can make those arguments. So if you're going through the situation, contact me, Greg Bailey at Arnold & Bailey, and schedule a consultation so we can discuss your options and objectives as we go through your divorce or custody process.